Right away, you can feel the judge isn't fully convinced, and that matters. In eviction court, credibility is everything. If your explanation doesn't make sense to the judge, your entire case can start slipping fast. So the real question is, can documentation save this situation, or is it already too late?
I hear what you're saying. That doesn't make much sense to me, but
Well, if I can go into it just for a minute, is that they were taking a large amount of medical expenses out of my check, and that's what slowed down my what I was
uh,
receiving. And I can show that statement, and that's what I was trying to explain to them, but they said it didn't hold any
I
merit to
got you.
assist in that area.
So were they saying that really that you wouldn't be able to afford the apartment if they're taking this out?
Yeah, because it was at that time.
Okay, gotcha.
Yeah,
All right. Let me ask you this, because this doesn't.
and I can show the documentation too.
No, I got you. Um,
This is a critical turning point. Programs like DHS and rental assistance agencies aren't just suggestions. They're often expected steps before the court shows leniency. Think about it. If help is available and you haven't applied, how sympathetic should the court be?
so you haven't applied yet through DHS.
No.
All right. I want you to do that, okay? Do that right away. It may not be much. How many people are in your apartment? Just you?
Yes.
All right. But that's still 400 we can maybe get. And then you've applied through SOS. I'm a little bit concerned if they're saying that because somebody's deducting something from your check, that all of a sudden creates a problem. But I mean, I get it on one side. All right. So, did they give you any other agencies or places to apply, like MAP or anything like that?
No, I think they might have did the same when the DHS was on when I think they said that day. There was no other ones that I know about.
Because there's another program. So here's what I want you to do. I want you to call Hawk back and without going into great detail on it, the other program has a higher income threshold, but their sustainability also, I think, is affected by that. So call back and ask Hawk, are there any other programs you can apply to?
Okay. Will do.
Okay. And then between now and the 8th, is there any amount that you can pay over to the landlord?
Yes. But tonight and the 8th, I can pay 15.
You can pay 1,500?
Yes.
But okay, so if I put you can pay 1,500 by the 7th.
Yes. Before the 7th.
Okay. So get that paid to the landlord.
Okay.
All right.
Okay.
If at worst, if you do that, we'll click away at that balance.
Okay.
And then if we can find something else, maybe Hawk could click in. I don't know, but we'll figure it out.
Okay.
Or try to anyway.
And then I do have all the supporting medical documents if anyone needs to see how they started.
I'm sorry?
I do have the supporting documents to show how the check got affected and when it got hit.
No, I got you.
Okay.
I believe you.
This adjournment is more than just a delay. It's a lifeline. The judge is essentially saying, you've got time, but use it wisely. Miss this window, fail to pay that $1,500, and this could quickly turn into a possession judgment. The clock is officially ticking.
But let's see what we can try to work out. So I'm going to adjourn this to the 8th of May, 2026 at 1 p.m. Okay, that's an in-person hearing, and I know you know where we are because you're in our access point. All right, so you just come down to the courtroom the next time.
Okay.
All right, and
Yes.
we'll see where we are, but make sure to get that 1,500 in, so then we can see where we can go from there.
Right.
Fair enough?
Yeah, fair enough. Two quick questions. What was the amount that you gave out at the bottom? Was it for what?
It was $4,095.
$4,095. Okay, all right. And also, does anybody know anybody who's hiring? Anybody who's thinking?
Okay.
Anybody?
Well, you know what? I appreciate you asking. I'd love to have a job service here, but I don't.
Okay.
All
Okay.
right.
All right.
All right.
Okay.
Okay, Mr. Wall. We'll see you in a couple weeks.
All right. Thank you.
All right. You take care.
Never a dull moment.
Yeah, well, that's right. But, hey, somebody might have said,
And just like that, we get a rare human moment in court. Asking if anyone's hiring mid-hearing? Bold, risky, but also kind of brilliant. Because let's be honest, when you're facing eviction, pride takes a back seat to survival. Would you have asked the same question?
yes, I got to give him.
I mean, I give him credit. It takes courage to ask that question.
It does.
Under these circumstances.
All right. Haverhill on Clark versus Morgan Ivory.
Yes, Rania Haddad for the plaintiff.
Morgan Ivory, they have not checked in. You may proceed. You've previously been sworn.
Yes, thank you, Judge. Plaintiff moves for a default judgment for possession. Rent to retain is $6,435. Attorney fees and costs in the amount of $170 for a total redemptive amount of $6,605 due and owing through the end of this month. We are seeking a writ date of 5/4/2026. No money judgment is entered. To my knowledge, the defendant is not a minor, incapacitated, or in the military.
Judgment to the plaintiff, that's by default for possession redemption amount in the amount requested with the writ issue in 10 days.
I'm sorry, may I interrupt 1 second? I'm so sorry.
Yes, please do.
I think maybe something got missed in the emails. That case was supposed to have been dismissed. I apologize.
Morgan Ivory?
Yes.
Okay.
Oh,
that is
you better. Okay, thank you. All right. So I will
we will submit a dismissal.
scratch this out. Case is dismissed without prejudice. All right. Thank you.
Thank you.
Haverhill on Clark versus Rico Crawford.
Rania Haddad for the plaintiff.
And Shanice Tripp.
Morning.
Oh, good morning, Tripp. How are you?
I'm well. How are you this morning?
I think I'm okay. Thank you for asking.
V. And this is how quickly things can go wrong. A default judgment means the defendant didn't show up. And in eviction court, that's often game over. No defense, no delay, just a fast track to losing possession. It's one of the harshest procedural outcomes in the system.
Nobody ever
Yes.
cares about the judge, but that's okay.
Oh,
All
okay.
right. All right. What is plaintiff's claim?
Wait, plot twist. Just seconds after a default judgment is entered, everything changes. This is why courtroom procedure matters. One missed email, one miscommunication, and suddenly, a case flips completely. The question now is, was this a save or just a temporary reset?
We are seeking rent to retain in the amount of $5,441. Attorney fees and costs in the amount of $170 for a total of $5,611. That's $5,611.
All right. All right. Ms. Tripp,
Yes.
how are you intending on getting that paid?
Okay, so I filled out the SCR. So that was on the 22nd. I'm waiting back for that. And I contacted Hawk. So, I have to have the balance down to like 3,000. So, and I have Friends Indeed also. So I'm waiting on all three of those, things to see what Friends Indeed want to do or if SCR will help. But then I will also have 1,800 by the 3rd of May.
All right. Okay, so you'll have 1,800 by the 3rd,
Yes.
and your monthly rent is about $850. So that's great because that'll
Okay.
maybe take away 1,000
Okay.
effectively on that amount, and then we got to figure out the rest of that. Okay,
Okay.
with the SER, how many people are in your unit?
4.
4? Okay, what, you and 4 kids? Is that?
It's me and 3 kids. Well, 2 adults. I'm sorry, 2 adults because he's 20.
Okay,
I'm
all
sorry.
right. was gonna say,
20. He's 20.
yeah,
Two
no,
adults and two
I'm not good
children.
at math, but that didn't
My
work.
son. So
No,
it's 2 adults and 2 children. I'm sorry.
two. Okay, so 4 people.
Yes, sir.
All right. But I may make an order that she's got to go home and count the people because I don't think she knows.
Tired. Look,
Listen,
see,
all
I'm
right.
at work. I'm on 16 hours. I'm sorry.
Okay, no, you're good. Okay, so just so you know, the max award that DHS will give you about.
Here's the tough reality. Assistance exists, but it's limited. When the rent owed is in the thousands, a $740 cap barely scratches the surface. This is where many tenants hit a wall. Too much debt, not enough support. So how do you bridge that gap?
$740. Okay.
Okay.
So that's the first thing on that.
Okay.
And then, so that's the maximum amount. You got to get with Hawk, you got to get under 3,000. And then you have to see what Friends Indeed may do.
Yes.
Okay. So you contacted Hawk. Did
Yes,
they give you an appointment day?
No, she took all my information. She talked to me and my son, and she just said because of the balance, if I could get that 2,000 paid, then she said that they will be able to give me an appointment to help because their cap is 3,000. So that's why I contacted Friends Indeed. But if they can't help me,
Okay,
I'll have
so-
1,800. So
No, I got you, but
yeah.
that doesn't make any sense with what they're telling me because they're supposed to give you an appointment regardless. But
Okay.
okay, so do this because I don't
Sure.
know what.
Now this is interesting. The judge is openly frustrated with the system itself. When even the court is confused by how assistance programs are being handled, you know something's broken. And it raises a bigger question. How can tenants navigate a system that even judges struggle with?
I'm gonna have to start yelling at some people, and I really don't want to.
Okay.
All right. Well, because it's confusing for you,
Yes.
confusing for me and the landlord because they're telling us one thing and then they're not doing that for people. And
Okay.
it's okay if I'm not going to give you an appointment, but just tell me that's not what you're going to do.
Exactly.
And then I could deal with that. But let's do this. Get the 1,800 paid by the 3rd.
Yes, sir.
See exactly then where the figure is. We ought to be about 1,000 down from where we are now, not
Okay.
including late fees that click in. There's a form that came in your packet called a rental assistance form.
Yes.
Fill that out. Put your SER tracking number on there and that you've contacted Hawk and you're waiting on Friends Indeed. Just put that on the form. Submit that to the court by Wednesday.
Okay.
Okay.
Yes.
And then I'll adjourn this out to the 8th of May, 2026 at 1 p.m. That's an in-person hearing, so somebody will need
Okay.
to be here. Okay?
1 p.m. I'll be there.
Okay. And then we'll figure out exactly where we're going to go from here. At least by that
Okay.
point, we'll have the numbers stagnant and figure out how maybe we can get to that $3,000 cap. All
Okay.
right.
Thank you so much.
And you're welcome. And on that other email that you're sending, can you just add on there that the court's understanding is that appointments would be set regardless of where they were, that they would at least be an appointment after the initial screening, particularly where there's a representation that she may be able to get under the 3,000. That makes sense? Okay. I just want clarification from them because I think they're just telling people stuff. All
And
right.
just as a side note, Your Honor, this case was filed in the name of Rico Crawford as well. So in the event that we are going to facilitate some type of a resolution document, Rico Crawford needs to be present in order to sign off, and Ms. Tripp cannot sign off on his behalf to any resolution document. And I just don't want him to be adversely affected. I'm going to assume that he's her 20-year-old son.
Yes. Yes. He's in school, so that's why he couldn't come today.
Okay.
But I understand.
He's in school?
Yes.
Is that what he told you? Or you know that?
He better not be lying. I don't need nothing extra. He better not be lying.
I got one of those. I don't know if he's in class, but I get you. All right.
I'm about to check his location.
Yeah, oh boy. I didn't want to get him in trouble. I'm going to blame it on counsel.
Yes, I'm gonna
tell him
tell
the
him.
reason you're checking is because of something she said.
Yes,
All
I'm
right.
gonna definitely tell
That's
him
okay.
that.
That's okay. We're the bad guy anyway, so.
No.
All right. All right. Thank you, Miss Tripp. You have a great day.
You too. Thank you guys so much.
Thank you.
All right.
Bye-bye.
And then I have Haverhill on Clark versus Hitchings, Haverhill on Clark versus Taylor. Those matters are dismissed on plaintiff's motion without prejudice.
Yes.
And
Thank
I
you, Judge.
think that may be it for you.
Oh, well, it's been a good morning. Thank you, Judge.
Yes, it has. All right.
Thank you. We appreciate you as always. Have a good one, everyone.
All right. Take care. We'll send that form over to you.
She already
you'll
did
have-
actually, so
Yeah.
yes, I'm not gonna make any comments as to how easy it is to us. I mean, I'm thinking there's like a chart, like just like for the what was it, the COVID relief, Sarah,
Oh, no, it's nothing like that.
Yes, no, this is a little less simpler, but yes,
This is
let's
just
go
really
with,
simple.
we'll go with Judge Simpson is brilliant. That works.
Pardon me.
Okay. Hold on one moment.
Oh, this might be a defendant.
Ma'am, you're trying to get our attention?
Hi, yes, pardon me. I just want to say, please excuse my tardiness. I had a time at 8:30 today, and I was wondering if I could get a
What's your name?
My name is J.L. Brewer.
That was one of the defaults, yeah.
That was a default.
Showing up late to court is one of the biggest risks you can take, and here, it almost cost everything. Default judgments don't wait. The system moves on without you. So the real takeaway? In eviction court, timing isn't just important. It's everything.
And do I have the file?
It is.
It's Mr. Dodd's case, yes. Hang on one moment. We're going to have to.
I appreciate it. Thank you so much.
Your Honor, I do not have the file.
We don't have the file. All right. So here's what I'll do without the file. I have a note. This was the one I had a note from. Did you get in employee verification or employer verification information over to Hawk?
I filled it out, but my manager, it didn't get there in time. So I have the papers, everything filled out with the number, email, and verification. It just didn't get there on the time, on the specific day.
Okay.
Everything.
So you have it?
Yes, I have it.
Have you sent it over?
I was gonna take it up there actually
To SOS or to Hawk?
to DHS because, well, actually, I'm sorry. I applied for two. I applied for DHS and Hawk. Hawk, I talked to Miss Alicia yesterday, and she sent over the verification, but she needed his email. So I sent over the email yesterday. And she, so that was yesterday. So we were trying to get it done before today, but it didn't happen that way.
Okay, it's okay. I'm just trying to make sure. The last note I have is that they were waiting on employer verification to determine your eligibility.
Yes. So
has that now gotten that information that you were to provide, or that's gotten to
yes.
SOS?
Yes. Since as of yesterday.
And then DHS you've also applied to? Yes,
I applied to DHS as well. They said because they needed verification, but I did the verification didn't get there in time, so I have to reapply. So I was going to reapply to see whatever they can get.
Okay, all right, I got you.
So Judge, I'm just going to make this easier for everyone. The plaintiff withdraws their motion or their default judgment for possession and will accept an adjournment for 5/8 at 1 o'clock so that she can get the documentation.
And just like that, the judge reverses course. Vacating a judgment is not guaranteed, but when it happens, it's a second chance most people don't get. Now the case resets, but the pressure? Even higher than before.
That's what I was gonna vacate the judgment I entered in any event. And so, ma'am, I'm going to adjourn your case over to May 8th.
Okay.
2026 at 1 p.m. That's an in-person proceeding.
Okay.
I'll need you to look in your rental packet or the summons packet that you have. There's a rental assistance form in there. I need you to fill that out with information on your DHHS application as well as your Hawk information. Fill that out, put that on there, and file that with the court by next Wednesday.
Yes, sir.
All right?
Yes.
Okay.
Thank you.
We'll see
Thank
you
so
then.
much. Okay, take care.
Thank you.
Thank you.
Oh,
you.
you're gonna grab. You'll take care of the file. All right. All right. I think finally that's it, Mr. Dodd.
I
All right.
believe so. Thank you, Judge.
Okay. Take care.
You do the same.
Tracy Group LLC versus Megan Davison.
Here I am, Judge. Give me just a second.
Sure.
Woohoo.
Evening. In the 5.
Your Honor, there was an email sent this morning, and I assume you're looking at it right now.
I am. Yeah, okay. All right, I understand it, but I'm presuming you're wishing to proceed with the default.
I am, Judge. With this,
All right,
this matter,
raise
we've
your
been,
right hand.
sure.
Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth? Self you got. I was going to say other right hand, but you got it. All right.
I do, Your Honor.
All right. Go ahead.
I'm familiar with, I am Dan Shemke. I am attorney for the Tracy Group. I am familiar with their books and records. And as of today's date, the current amount of rent due is $17,600. There's an additional $275 worth of late fees on top of that for a total due and owing of $17,875. I am not, and my client is not concerned with service fees or court costs at this point. We think it highly unlikely that we're ever going to get paid. And for that reason, we'd like to proceed based on the balance due and owing of $17,875.
Well, except for the fact, counsel, there's a money judgment. Oh boy. Okay.
Judge,
This is a technical but powerful moment. The case has a mismatch between the notice and the complaint. That might sound minor, but legally, it's a big deal. Filing errors like this can delay proceedings or even derail a case entirely. It's proof that in court, details win cases. Intro. What we just saw is eviction court in its rawest form. Stress, confusion, second chances, and razor-thin margins between staying and losing everything. One payment, one document, one appearance can change the outcome entirely. So if you're watching this, ask yourself, would you know what to do in that moment?
Here's what I'm going to have to do. Hold it. They're going to get the adjournment in any event because you've got to correct something. I'm going to adjourn it to my next date, which is May 8, 2026 at 1 p.m. That's an in-person hearing. I'll consider this the first hearing. Counsel, you've got to correct the complaint. I've got a notice to quit, which is a non-payment notice to quit. I have a complaint, which is a termination. They don't match.
I get it, Judge. I get it. And one day.
But the good thing is you can amend the complaint. So rather than having to start all the way over, you can amend the complaint to a non-payment of rent complaint, and then we can proceed on the 8th.
Do I have to file anything other than the non-payment of rent complaint as an amended complaint?
No, you
Judge?
just you could file the non-payment of rent complaint, just indicating at the top that it's an amended complaint, and then effectuate service somehow. So then,
all right.
All right.
I will do, Your Honor. Thank you very much. As always, it's a pleasure.
Yes, sir. You take care.